applicant is requesting the court to afford him ensures that he is not disadvantaged in the conduct of his case and has a reasonable opportunity to prepare for his case and challenge the prosecutor's evidence. That is very succinct. It is beyond reproach. The provisions of Section 35(3)(b) are very specific, my lord. And we're bearing in mind what the Constitution says about the limitations of the rights that are contained in the Bill of Rights. Now, number 18, this is an emphasis of what has been said in our introduction, that the applicant had at no point anticipated that almost 23 months after the commencement of the trial, the prosecution will confront him with entirely new evidence, which would have required him to start the preparations of his defense in the matter on this new evidence, as if the matter is starting from the beginning. Now, this is very clear now. When a person gets confronted 23 months into the trial and the state having led more than 60 witnesses, they come up with exclusively new evidence. What does that mean? It simply means that the accused or the applicant in this case gets taken to the very first day on which he's supposed to be pleading. He has to start to prepare this trial or his defense as if this matter is starting de novo, specifically with the introduction of this new evidence. Now, what is worrisome, again, is the fact that the prosecution offered no compelling reasons why this evidence was not made available to the defense and its purpose in time, so that the defense could deal with it timelessly. We are submitting, my lord, that it is therefore fair that it's late availing of this, the late availing of this information to the defense should be reckoned as a factor which entitles the defense to request a reasonable time to prepare on it. The Constitution gives the applicant that right and entitlement. Just a very quick one. I would have been expected to cross-examine Mr. Mabasa immediately after he proffered his evidence. But the worrisome factor is I had no opportunity even to take instructions from Mr. Nyube, accused number 3. So how could I then have been in a position to start to cross-examine Mr. Mabasa with new evidence that he proffered, that we did not even have the slightest idea what the nature of evidence would have been, my lord? That would have been very grossly unfair to the accused. And beyond that, the court would have noted that at one point or the other, accused kept on requesting indulgence that I should come and see him. He came up with a number of issues that we need to deal with before we can start to cross-examine Mr. Mabasa. It would have been very unfair and very prejudicial to this accused person if I immediately started to cross-examine Mr. Mabasa on this new evidence, because I would then have been found wanting